Welcome back to Legal Principles of Surveying, Spring 2014. My name is Chris Riles, and I am your instructor at East Central Community College in Decatur, Mississippi. Today we're going to talk about riparian and littoral boundaries, Chapter 9 from Brown's Boundary Control and Legal Principles. And we're going to talk about how these boundaries have an impact on your surveying future and anything that deals with water-based boundaries. Let's talk about what riparian and littoral mean. The term riparian refers to a parcel that is adjacent or abuts a moving body of water. So, for instance, if a boundary is defined based on a stream, a river, a branch, a creek, a lake, or not a lake, but lake's littoral, excuse me. Anything that's a moving body of water is going to be termed as riparian. And basically that just means the water is moving. It's constantly moving. Now this could be navigable, unnavigable. We'll talk about that in just a little while. But riparian just means moving body of water. Littoral refers to a parcel that's adjacent or abuts a non-flowing body of water. And oceans are considered to be non-flowing bodies of water. Even though we have changes in the tide, that doesn't necessarily mean anything about the movement of the body of water. And so we're going to talk about tides and all that shortly. The laws that control rights to riparian littoral lands are complex, confusing, convoluted, and constantly evolving and changing. And the reason I included that on the slides from your textbook is it's important to understand that when we talk about these boundaries, there's a lot of generalization. And the reason there's a lot of generalization both in my slides and in your textbook is because in a lot of cases, local law and local statutes and traditions are what much of the littoral and riparian boundary legal standing is based upon. So we really want to make sure that when we do anything with riparian and littoral boundaries, that we try to figure out exactly what the legal repercussions are. Why is it so confusing? Well, each state has their own way of describing the rights to riparian and littoral owners. How you get those rights, how those rights are defined, this is very similar to easements. The surveyor is responsible for understanding the terms and extents of the law regarding riparian and littoral boundaries within the state law. Just like easements, where the surveyor needed to understand the parts of an easement, how an easement worked and flowed, how the writing was done, how to write a good easement, the same goes for littoral and riparian boundaries. Now, I looked up in the MS Code, Title 29, Public Lands, Buildings, Property, Chapter 15, Public Trust Tidelands, Mississippi Annotated Code, Section 2915-5, contains information regarding the laws for riparian and littoral owners. And it's actually very short. It can be found at the link below if you will use your link in your PowerPoint slides. And you can go to that website and it'll show you the Mississippi Code. And the cool thing is that it's really plain and simple. Some states it's not so simple. Now, littoral, this is your Mississippi Code. Littoral and riparian property owners have a common law and statutory rights under the Coastal Wetlands Protection Law, which extend into the waters and beyond the low tide line, and the state's responsibilities as trustee extends to such owners as well as to other members of the public. So this is saying, look, anybody who owns land that is littoral or riparian, they have common law and statutory rights. Common law, we're going to find out in a little while, is not so clear on the definition of littoral and riparian rights, but they're still statutory under the Coastal Wetlands Protection Law. And this extends into waters beyond the low tide line and just all waters and within the state's responsibility. And this responsibility also comes to the public, so for public use of certain riparian water. Now, from our textbook, the doctrine of riparian rights and boundaries was grounded in the Roman Code and modified under ancient English law and finally adopted in the New World with the basic common law principles intact. But even with the basic principles intact, we found that they're lacking very much so when it comes to common law. So this is an important quote from your textbook. The boundary property surveyor is cautioned that riparian and water or littoral boundaries are complex and in a constant state of flux, and that no surveyor should undertake to locate a water boundary unless qualified to do so. You'll see this quote at the end of this chapter. Because it's important to note that federal and state court decisions about riparian and littoral rights are constantly being argued and changed. It's going back and forth due to the nature both of taxation and the recording of land ownership. The reason why we keep going back and forth is it has a lot to do with acreage, has a lot to do with changes in the property, and as we'll find soon, there's changes even to the boundaries by natural and artificial forces that cause the boundary location to become ambiguous. And writing of the boundary, just like with easements and everything else, the description needs to be very clear to what is meant. A surveyor should never attempt to make a decision on the survey without careful research and seeking advice from competent legal professionals. And I'll say that several times in this chapter, because just because you had a class in legal principles of surveying does not make you an expert in riparian and littoral boundaries. And even though I teach this class and I read and study and I use a lot of different references, I would not say that I'm qualified at this moment to go out and perform a riparian and littoral survey. It involves years of experience, but also not just years of experience, but looking at the full picture and trying to come up with a intent from the original boundary creation, so that we can find out, okay, what was the intent of the original owner and the original surveyor to how these boundaries should be laid out, and the laws that attach to them, because they are very important. Now, some of the definitions, I wanted to define this for you a little bit, because you'll see this throughout your textbook. I tried to use the same content as what your textbook does, but if you read other texts, they use different content. Let's look at some of these tidal definitions. I got a little picture here. You can see the mean sea level at the top there. That's the average sea level over a 19-year period. And this mean sea level was used in the past and is somewhat used today to help us determine elevations above sea level. Low and high water. Now, these are average, predictable, standard tidal changes. We'll talk about why the tide changes in a moment, but you see mean high water, mean low water on the graphic. Mean low water is the mean low tide, so when the tide is low for natural causes, just normal, predictable causes, that's mean low water. And then mean high water is high for the exact same reasons. The tide has come in, the tide is high. And so those are just two examples of that. If you look at low, lower, and high, higher water, basically it's above and below the general extent, and these extreme tidal changes could be due to weather or even lunar events. And these changes could be catastrophic in some cases. So it's not just the water got higher one day. It's because something caused it to happen. Well, because of this, we call it mean high water, mean low water. So you can look at the graphic there. Kind of gives you a little bit better explanation of what's going on. Okay. Now, getting into this and why we use these terms. The Massachusetts Colonial Ordinance of 1641 was the first recorded example of an ordinance that was set up in order to provide legal guidance for land boundaries bordering watercourses in the Massachusetts colony, but also just in the colonies in general. Many states took this example and modified it and made it their own. In fact, this applied to Maine even, and still applies to Maine today, which split from Massachusetts in 1820. So even after almost 200 years, they maintained this and kept this, and it's even still law today. The way it worked was lands bordering tidal water, so you're looking at littoral lands here, will take the low tidal mark, or mean low water, or 100 rods, 1,650 feet below the high water mark. If you look at your graphic, kind of flip back with me for a minute, you look at the low tidal mark, which is the mean low water, and we're talking about the concept of they're going to take the mean low water, or they're going to go 100 lengths out from the shore and take the mean below the high water mark. So they're going to take, that many below the high water mark. Now, that's a lot of feet. That's a lot of change. The concept here could be somewhat convoluted. They also said that ponds larger than 10 acres cannot be owned or granted by the local jurisdiction if they lie in common with privately owned boundaries. This means, you can't own a pond if it's bigger than 10 acres, because it then starts to become navigable or useful for things other than just people getting out there on a boat. It's something that you can use, and the local jurisdiction, they can't own or grant that if they lie in common with privately owned boundaries. Instead, local jurisdiction has to allow it to sit and stay. Now, many states have enacted parts or all of this ordinance. If you look in Mississippi's laws, you'll see a few things in Mississippi's riparian and littoral laws that dictate back to the Massachusetts Colonial Ordinance. But, each state kind of has twisted and made their own. Remember, this is a statutory layout rather than a federal kind of law layout. Now, there are 25 principles in this chapter. There are some principles that I will just kind of skim over and give you a brief description for. Others we'll spend time on. And we're going to talk about them when they pertain to riparian and littoral boundaries. Now, as we come to these concepts, We'll discuss some principles that apply. Some principles will have several slides, others will have one or even half a slide. You really need to read the entire chapter for future reference to riparian and littoral boundaries. I would suggest this book, and I would also suggest you get a copy of Clark on Surveying and Boundaries, the 6th edition. It's a difficult book to find sometimes, but I would recommend that you get a copy of this, because a lot of the text that I got out of our textbook, I went back and checked with this book as well. And they're both written by, if you look at your textbook is co-authored by Walter G. Robillard. Well, Walter G. Robillard and Lane J. Bowman wrote Clark on Surveying and Boundaries. So they kind of give you an idea. It's the same people writing it, but they give you a little bit different look into it. So I would recommend that. There are also other books that you can use. I also use the Manual of Surveying Instructions 2009 to give me some idea on the federal side of things dealing with littoral and riparian boundaries. Now, many of these rules that apply to riparian and littoral boundaries refer back to English common law and the rights that are attached to common law. So if you remember that bundle of rights, it comes back into that concept of how rights come into play with boundaries. Now, Principle 1, the high seas are international waterways that lie seaward of the territorial sea, which is subject to the exclusive control of coastal states and or nations. Now, international seas cannot be owned. That's a common understood thing. When you're out in the international ocean, you can't own that. Hence the term international. It's not owned by anyone. The territorial sea is claimed by a country, and in the U.S., it was originally set at 3 geographic miles. We also call them Great Circle miles. They're based on the curvature of the Earth, not on just a linear mile. In 1988, by presidential proclamation, we enlarged this distance to 12 nautical miles, except for a couple of states which decided to stay with the 3 mile. This concept of extending this was a territorial thing. We don't own the water, rather we own the territory the water occupies. Now, the reason this was done was for several reasons, but one major one is minerals. Minerals on the continental shelf bordering the U.S. are claimed even beyond the 12 nautical miles, but this gives us the 12 nautical miles to be looking and digging, and we can even go beyond that. However, fishing rights are claimed up to 200 nautical miles from its borders, and in the case of the Gulf of Mexico, there's a very different form and idea of who owns the Gulf of Mexico, because nobody really fights us over it, and we go and take a lot of minerals out of the Gulf of Mexico, and so there's some different rules and laws that apply to when we talk about high seas. The Gulf of Mexico is a little bit different. Principle 2, offshore submerged lands were originally considered to be owned by the states. The U.S. Supreme Court ruled in 1947 that the federal government, not the states, had paramount rights to these territorial waters. And this was a big deal. The U.S. Supreme Court said, hey, federal government has jurisdiction here, not the states. States seem to back off and give it back to the federal government. However, in 1953, notice only 6 years later, Congress specifically granted these submerged lands back to the states. And so this was an idea and a concept of state versus federal jurisdiction. As with the statement made at the beginning of this chapter, the laws are constantly changing with littoral rights, and these offshore submerged lands are a perfect example. If you read in your textbook about all the things that changed there, on page 235 you see a lot of the things that are under the provisions that the Supreme Court laid out, including fee title and all rights to minerals and resources up to a geographic distance. All those things came out of this decision. And this decision is kind of the landmark for what the state law is today. Now, because Congress gave these lands back, the concepts have changed since the Mississippi Code of previous to 1953. Now, these lands are seaward of the coastal low water mark, so they're out in the sea, past the low tide. And submerged lands are typically rich with oil and other minerals. So they're submerged under the water. They're not really ever shown by the changes in the tide. They're still out under the water. And the jurisdiction of these has really come down to a state issue. Now, even though we say that now, this is still subject to change. It's changed in the past. There's no reason why it might not change in the future. In 1953, the submerged lands were quitclaimed to the states and overturned by the decision by the United States versus California. Now, the Supreme Court decided that all the rights to minerals were quitclaimed to the states up to 3 geographic miles seaward of the coastline in the Atlantic and Pacific Oceans. States bordering the Gulf of Mexico could claim up to 9 geographic miles, and this was due to just looking at the Gulf of Mexico being a different body of water. All bays unless acquired by the federal government or quit claim to the states. And this acquired by the federal government means that they were used for a federal purpose, and there are some that are used for federal purposes, but most of these bays went back to the states. And the U.S. reserved some lands beyond the 3 miles for minerals and would control commerce, navigation, and defense within those 3 miles. So the U.S. federal government said, we'll reserve some lands beyond 3 miles, but we're going to give you national defense within those 3 miles that the states do own. So the defense of the states is up to the federal government, which comes back to the U.S. Constitution in general. But also to control commerce and navigation, your Coast Guard will guard these regions. They also decided that the Act stated the 3 mile mark was measured from the low water mark, which is low tide, along the part of the state that's in direct contact with open sea, not parts of the state that are in indirect contact or have a island in between or an archipelago. If there are offshore rocks located seaward of the low water mark, a 3 mile mark is measured from these rocks seaward. And so the concept was we don't want to start measuring until we're to the furthest extent of the land that could be owned by the state. Now, interestingly, many Gulf states sued for modified seaward limits. This is what I was talking about. Texas and Florida were awarded 9 geographic miles due to historical claims, and others retained the definition of 3 miles because of what they wanted to have for jurisdiction. Now, this was once again, the Gulf's a different place than the Atlantic and Pacific Oceans. Looking at principles 3, 4, and 5, and I'm going to read those to you. Principle 3, tidelands generally are the lands covered by the daily tides and are situated between the lines of mean high water and mean low water. There are some exceptions to the general rule. Tidelands are owned by the respective states, although sales by the states are not uncommon. Even when tidelands are sold, the public trust may be reserved, even though not stated. Principle 4, submerged lands that meet federal tests for navigation are owned by the public of the respective states. Some states own the low water mark, others to the high water mark. The public has an interest in the high water mark, up to the high water mark, which is called the public trust. And then Principle 5, submerged lands that do not meet the federal test for navigation are customarily owned by the adjoiners. Tidally affected submerged lands are an exception, and they may be considered for navigation in law regardless of their actual capacity to sustain navigation. Tidelands, and when we're talking about tidelands, are lands covered and uncovered by ordinary tides. So if you're thinking about sand dunes and sand barges and land that's covered and uncovered as the tides come in and out, there's some prevailing discussion about jurisdiction with tidelands. And you can read from these 3 different principles that sometimes things are stated and sometimes they're not. Even though there are laws about the boundaries of ownership of the tidelands, several states have exemptions or are exceptions to the generalized rule. And so, once again, you're going to see this throughout this chapter. A deeper understanding of the state law in which you're practicing can make a huge difference, not only in the accuracy of your survey, but also the integrity of the survey and how well it holds up in court. The first part of the Mississippi Code defines the state of tidelands and submerged lands for Mississippi. If you read that section, it talks about how tidelands and submerged lands are to be treated in the state of Mississippi. There are federal tests according to Principle 5 described in your textbook for submerged lands, but each state holds its own definition of public trust lands. And it's stated in Principle 5 there that you really can't define what's a submerged land, what's a tide land, without looking at the federal notes and the federal law first, and then going to the state law secondly. So that's a prevailing discussion on tidelands. If you ever do any work in the coastal region, I would encourage you to find somebody that has dealt with these before so that you can understand them better through them. Principle 6, we're going to also read from the textbook. Swamp and overflowed lands were originally part of the federal public domain, and they were granted by the government to the public land states beginning in 1849. They are not subject to the same public trust provisions that attach to tidelands. Swamp lands were granted to the government to some of the public land states, starting with Louisiana. Now, I say some because there are some public land states that don't have swamplands. They just don't have them. But if you read through here, other states starting with Louisiana, including Alabama, California, Florida, Illinois, Indiana, Iowa, Michigan, Minnesota, Mississippi, Ohio, Oregon, and Wisconsin were also granted swamplands. Now, one of the exceptions was Arkansas. According to the Manual 2009, and I'm talking about this Manual Surveying Instructions, the exception was Arkansas. In the Arkansas Compromise, in the Act of April 29th, 1898, this reverted all title of the remaining public swamps back to the federal government. This does happen, but notice that a lot of the states that have been granted swamplands, most of them are on the eastern or central part of the United States, not in the western part, because remember, the western part is mostly owned by the federal government. So the Arkansas being the exception here really has changed a lot of things, and I'm really not sure about Missouri. I'm not really sure about some of those things. That might be something interesting to look up. But according to the books that I've read and the things that I've pulled out, this is true, that it was granted to some of the public lands states, and one of the exceptions was Arkansas. The public has certain rights, Principle 7, in the beds of navigable waters below the high water mark. The states have power to exercise these rights on their behalf. So the public basically has a right to use navigable waters for commerce and recreation. No one can own a navigable river, stream, bay, tidelands, or submerged lands. They belong to the state for the public trust or the public use. Now, what's really important about this is a lot of people will say that they own this creek that's along a boundary. Well, that's not necessarily true. And navigable waters, if the water's dried up, you would own the bed. But the public has rights to the bed as long as it has water in it. Concepts would go back to Oxbow Lakes and some of the situations we see along the Mississippi River, but any navigable river or waterway is considered to be public use. Now, the significance of this doctrine, according to your book, to the property owner, to the surveyor, is that to fully define the limits of public interest in real property, the locations of both the high and low water marks need to be determined. It's really important that we determine both of these, because remember, we're talking about the high water mark here with the public having certain rights, but some states also look at it as the low water mark depending upon the state that you're surveying in. Once again, you need to know your state law. Principle 8. In most coastal states, the boundary between tidelands and adjoining uplands is subject to private ownership is the mean high water line. However, a number of states, including New England states and states subject to civil law, are derived from early Roman law and recognize other boundaries. Now, it's important to understand with Principle 8 here that we're looking at how boundaries are defined based on where high water mark is, where mean high water is. The definitions of these boundaries vary from the following measurements of location. There's two mentioned in your book: the general tide changes and then tidal datum planes. We're going to talk about these two things. Now, tide, as we know it in a generalized term, is the alternating rise and fall in the sea level produced by the gravitational force of the moon and the sun. There are other factors, but tides are pretty well predictable. If you use this link, you can look at some tide predictions. I would look at Mississippi and click on some of the stations. You can, if the data is available, you'll see the prediction versus the actual water level, and you'll see this rise and fall of tides that is predictable, and you'll see how close it is. And most of the time, it's pretty close. Tides are generally operate by these cycles and these lunar ups and downs. Tides can be predicted by the following transits of the moon. It can be done looking at the upper and lower culmination of the moon, and it kind of makes a sine wave when we talk about these transits. And so every 12.42 hours, the tides will be affected by the location of the moon in reference to where you are on the Earth. So if you look at this, I kind of grabbed a little graphic from the website there. I show you the high and low tides, and what you see with the high and low tides is you see it kind of following. Now, where it doesn't follow the prediction, where the water levels are a little different, we then need to come back and say, well, what happened to the water levels? Why are they higher? Why are they lower? But it kind of makes a sine wave, and any of you that have taken a geographic science or look at a geometry class, you've seen a sine wave before, okay? And this is all based on the location of the moon in reference to where you are. Now, tidal datum planes are a little bit different. Instead of looking at one location or high and low tide over a short period of time, this datum is developed based on using a very accurate collection of point data on the surface of the Earth. Now, a tidal datum is developed using averaged periodic measurements over a 19-year period, a lunar node or a lunar cycle. Now, Since the beginning of datum development in the U.S., the measurements were taken at several locations along the coastline to ensure the best possible collection of tidal data. However, it's important to note that tidal datums should not be confused with what we call vertical datums. So when we talk about vertical datums, the North American vertical datum or the National Geodetic vertical datums, those datums are not the same as a tidal datum because those datums are based off mean sea level only, where the tidal datums are based off mean tide level, which is a very different concept because it deals with the tides, not the level of the ocean. And I hope you understand that they're not the same thing. Mean tide level is defined as the average of all the half tides midway between high and low levels over the 19-year period. Mean sea level is going to be different from mean tide level because we're looking at a midway point between highs and lows which change constantly versus a mean sea level that's going to be something that's defined over several hours, not dependent upon tide, but rather looking at an average of overall. So it's a little bit different in the way that it's measured, but we still use a 19-year period or 18.6 years because it's important that we use that lunar cycle. Now, from the 1660s, there's evidence of tides being used as boundaries between private and public or governmental lands. And a lot of times the rules about tidal boundaries were conformed to fit the needs or wants of the particular government or ruler. If you look in your book on page 241, you'll see some examples talking about Lord Chief Justice Matthew Hale in England and how those things change. You'll also see some different court cases there, both in the UK but also in the United States. So there's no clarification for these boundary extents in the U.S. until 1935. In that case, where I think we looked at the Borax Consolidated versus the City of Los Angeles, and that court case kind of defined from there on out the clarification of these boundary extents with tides. Science was employed to give unbiased results, and that's important. Before, it was based off feeling and based off understanding of tides and how it should be done, and this kind of solves some of the dilemmas, but still, this is a commonly disputed legal issue. It's important to note that even though we use science to define things, and even though we try to use the best unbiased method, there are still going to be exceptions to the rule, and there's still going to be disputes about it, regardless of how we do it or what we do with it. It's just the way it is. Principle 9. In most of the United States, the boundary between public trust and submerged lands in navigable, non-tidal waters and adjoining upland subject to private ownership is the ordinary high water mark. Now, this is in most cases the high water mark is used as the boundary. This has traditionally been defined as a mark found by physical inspection of the bank. Hydrological evidence is also now being used in some instances. In some states, the boundary is the ordinary low water mark. So, once again, it differs. It changes. Now, early decisions regarding these non-tidal waters were based on differing opinions from differing people. Settlers that had lived in England all their lives didn't see very many freshwater rivers that didn't change with the tide. But when they moved to the New World, they realized we don't have as much tide lands as we do freshwater claims and freshwater lands. So the mentality had to change a little bit between the settlers and the originators from England. Now, English common law offers little opinion regarding non-tidal water boundaries. Coming back to the whole concept of what do we do with the common law, it offers very little because much of the common law refers to water bodies that are affected by tidal changes. And this causes problems. Now, England didn't contain many bodies of water that weren't affected by the tide, so it worked for them. But when we come to the New World, it just doesn't work as well. So their use as boundaries brought about a whole new set of problems for settlers because we were trying to determine what the common law would define with non-tidal water boundaries. Now, initial rights were to the adjacent landowners to the center of the bed, regardless of what it was, whether it was the center of a creek, whether it was the center of a river, center of a lake. That's the way it was. As long as tide had nothing to do with the body of water, this was the original rights that were set down. But some of those things have changed over the years. Now, determining the high and low water marks. The manual, which I'm speaking once again of the Manual of Surveying Instructions 2009, instructs the federal surveyor to observe the high water elevation by evidence in soil, vegetation, and other determining factors. The determination of high water is very complicated, and it's a practice that must be backed up with some determination using collectible evidence. A lot of times they'll use photographic evidence to make sure that you identify these things well. But here's 4 things that your book identifies, and I think these are 4 very good things to identify. First of all, various geomorphological features. You could see it in the rocks, you can see it in the roots, you can see it in how the ground has changed and the earth has changed. You can also see how soil and silt have been changed and moved. Vegetation, how the vegetation is growing, how the bank is set up, how the bank is being eaten away by erosion or being filled up by accretion, or what's going on here. Changes in the character of the soil. You can tell soil changes based on water flowing over it or running through it, and it does change the character of the soil and can be identified easily. And then also other hydrological evidence, evidence of flooding. In instances in swamplands, a lot of times high water is determined based on how high the rings are around certain cypress trees in order to determine that these cypress trees are at the high water or the low water marks. Other forms of identification. Each state uses its own statute law to determine how non-tidal boundaries are defined. Now, this information is from the 2009 Manual of Surveying Instructions, but I want you to look at this. 12 states use the high water mark as their location for non-tidal boundaries. So if you own a creek bank, you own to the high water mark. 12 states. 17 states use the low water mark. So there's a larger percentage of low water mark states. 5 states have a mixed policy for streams and lakes. Everything else is kind of, it depends. And it's a mixed policy. 5 states use a private ownership policy. This pertains to the upland owner having full rights to exposed banks. So if you have an exposed bank, guess what? You got rights to it. And it's based on private ownership. This includes Mississippi. Interestingly enough, if the soil is exposed, you own it. That's basically the way it works. 2 states have policies that are currently disputed, one of them including Nevada, which is not surprising, but Nevada is has had a lot of land issues just from different other problems out there, including minerals and oil and gold and so on and so forth. Colorado, New Mexico, and Wyoming have no real set policy. They don't have a policy in place for identifying non-tidal boundaries. And Texas and Hawaii, like everything else with Texas and Hawaii, have their own unique policy. I think gradient boundary was the terminology used for Texas, which is kind of funny that Texas and Hawaii are always the odd cats out when it comes to surveys. Now, Principles 10 through 15 pertain to the general rules of accretion and artificial changes in the land, avulsion, erosion, and reliction. And if you'll look at these, they're really general, really short. The Principle 10 is the general rule that boundary follows the changing shoreline. So we're going to talk a little bit more, instead of just about these principles, which are very simple and you can read them yourself. We're going to talk about these 5 different things and how they can change water boundary locations. So these change the water boundary locations for parcels adjacent to water boundaries. Once again, many state laws are statute-based and differ from state to state, and laws on how these things are viewed, well, that's going to be dependent upon your own state. Now, this is coming from Clark on Surveying Boundaries, the 6th edition. The gradual deposit of material along a bank of a lake or a stream that results in the building up of a bank at a rate of imperceptible to the eye is called accretion. So if it's slowly gaining soil but you can't really tell it by the naked eye, that's accretion. Artificial changes will be a gradual or sudden change to material along the bank of a lake or stream, resulting from imperceptible or obvious changes to the bank. So if I come in there with a bulldozer and change the bank, that's artificial. Avulsion is a sudden catastrophic change in the stream course or direction. This could be due to a flood. This could be due to a change in the direction of a river. Also, in the past with the Mississippi River and the Yazoo River, any kind of earthquake or changes in the Earth's crust can also change how a stream course is directed. Erosion is the wearing away of the bank by action of the water. Everyone, I think, has seen erosion. If you've been anywhere in Mississippi, you've seen it. And reliction, the gradual uncovering of land caused by the retreat of water. And this gradual uncovering of land could be that water is dropping in volume and you're seeing more and more land. In Mississippi, the reliction there, you would own the land that has been relicted. All right, going to Principle 16. We're kind of skipping ahead here, skip through those other principles because they're pretty easy to read based on those other principles. Principle 16, the laws of each state as opposed to federal laws control the apportionment of riparian rights. Water frontage, not total acreage, or upland lot line controls the apportionment of riparian rights. The point of departure for apportioning riparian right is at the intersection of the upland lateral boundary and the actual shoreline. Now, that makes absolutely no sense to most of us because this is a legal term and a legal set of terminologies. Again, state law dictates the riparian rights within each state, and they may use different mathematical and geometrical methods by which to determine where the boundary line falls. It's imperative that the surveyor become familiar with the laws in your state because each state's different, and you need to know the laws that dictate it to your particular state. Now, principles 17 through 19 define the general mathematical and geometrical methods, and I really encourage you to look in your textbook. Look on page 251. It gives you some pictures, some ideas of proportionate shoreline method. It would be a good idea to look at those and read through these to kind of get a little bit more information. But these are generalized for the textbook. Once again, know the laws of your state before you go out and survey a piece of land that's going to have something to do with riparian or littoral boundaries. Principle number 20, I'm going to read it from your textbook. Principle number 20 states, the United States can regulate activities on all navigable waters of the United States. Proper exercise of this power does not entitle a property owner excuse me, to be compensated for the taking of private property. Now, the U.S. Constitution gives the government power over navigable waters both in commerce and regulation of use. Now, this once again makes all navigable waters public domain or public use land. The Bureau of Land Management is the only branch of the federal government that has the power to determine the navigability of a waterway. The EPA can't determine it. The General Department of the Interior can't determine it. The Census Bureau can't determine it. The Coast Guard can't determine it. Only the Bureau of Land Management is allowed to do that. And the reason is because they're the ones that are in charge of all the federal lands anyway. And in some cases, because the federal government has power over these lands and waters, the federal government is going to have their surveyors determine what's a navigable waterway and what is not. Looking at Principle 21, riparian and littoral property is often subject to public regulation, creating regulatory limit lines different from property lines. Their locations can affect the utility of real property and therefore be as important or even more important than actual property boundary lines. Public regulation is a factor for the creation of extents of riparian and littoral boundaries. That's just a general case of all. Public regulation is part of it, and changes to that are localized to particular portions of a state. They may require a rule or statute to make sure that these boundaries are legally covered effectively. In some states, you've got issues with stream avulsion because of high water volume coming through if you think about some of the, like Alaska, for instance. Alaska has a lot of water moving through at certain times of the year causing floods. Avulsion happens, reliction happens. It goes back and forth, a lot of erosion, and in some cases even artificial from mining. So Alaska is going to have different laws and have a more public defined local regulation. If you look in page 256, it talks about California about halfway down through the page, and talks about how California had prohibited this construction that encroached the seaward of the mean high water line at certain times of the year, in any time of the year. And so this was something for California to do, but it wasn't necessarily done for every state. So once again, it comes down to principles that are affecting your particular state. Now, principle 22 through 23. 22 is, unless a riparian boundary is present, there are no riparian rights to attach to any parcel of land. Well, that makes perfect sense. If there's no rights to it, then there's no rights to it, period. Also in principle 23, when ascertaining riparian boundaries on streams that have multiple branches or beds, one of the most difficult problems is to determine just which of the multiple beds is the main bed of the stream for which the boundary is applied. This takes a lot of experience, I will say, but also understanding of how water flows and watersheds and how it works, and should be determined by a qualified professional or no rights should be attached to the property. And that's just the way it is. If you can't determine that it's riparian and where the mean water line would be, the high water, or even where the center of the line in some cases will fall, then there will be no riparian rights tied to it. Now, because of conflicting issues in court cases, the determination of riparian boundaries must be very, very, very carefully performed with repeatable and defendable methods. So you need to be able to defend the methods by which you came up with mean high water, mean low water, and particularly dependent upon your state law and reading your state law and understanding this is what my state says about this. Now, Principle 24, when riparian rights are created, they may come in conflict with the application and the principles of boundary location, and these rights depend on how the rights were originally created. Riparian boundaries could even be more ambiguous than traditional boundary locations. And I can see where that is. I've never had to deal with riparian or littoral boundaries in practice, but reading some of the court cases and reading through the text and reading through the laws, I can see where it can become very ambiguous to what is meant. That's why each state has its own kind of set course of rules, but even then local rules may change those statute laws. With confusion as a factor in riparian and littoral boundaries, the way these boundaries are defined can conflict with other boundary rights and locations and even cause further confusion, which leads us to Principle 25. When original riparian boundaries are destroyed through natural causes new riparian owners created, if the land reemerges as the original boundaries, they are not revived. And what that means is the boundaries are not revived from their originality because they have been changed. Now, don't misunderstand this principle. Boundaries may, quote-unquote, disappear, but you really need to use a great deal of evidence gathering and investigation before you determine exactly where the rights and the locations of the boundary are. Because if you just do a halfway job and you don't really investigate deep enough, you can put yourself in a whole heap of trouble. In the event that they're not found, the new boundaries stand and the original boundaries are not revived or brought forward again. And the reason is we want people to have use of their land. That's kind of the situation. In a situation where we have avulsion or accretion, or we have some artificial change or erosion or even reliction, we want to make sure that we don't change the riparian rights and locations unless there's no evidence found to the contrary. That's just kind of the way it goes. So some conclusions about this chapter, and this is a very good quote to end this chapter with. It's put on a little box on page 258. You really need to read that. Before a surveyor makes a final determination of a riparian or a littoral boundary, I'll say, the surveyor should consider all possibilities and then give weight to each possibility, and then select the one that the evidence in the law most closely supports. And I couldn't set out a better outline of how to do this than this right here. This is a very, very good outline. Also, first, the surveyor should determine if he or she is trained and capable of addressing a riparian problem. So many times I hear of people that are experts in a certain field, and you will never hear me call myself an expert, because there are always things that could be learned, always things that can be changed, and my opinion can change from time to time on certain things. Just because you finish this course and you read the chapter and you know it in and out and you do well on the test does not make you trained and capable to determine littoral and riparian boundaries. Doesn't happen. If you come across a riparian or littoral boundary, I encourage you strongly to spend a great deal of time researching before you make a decision of any kind, and even go back and talk to people that have dealt with these situations in the past. If you look at the examples on page 258 where it talks about extension of the upland sidelines without changing direction, so on and so forth, there's several different things there that your textbook defines as a few of the possible choices that may be considered by surveyors and courts, or whether a riparian boundary would be located by what. And this is also a good little part of the chapter, page 258 and 259, talking about your role once again. Remember, we're here to identify things and identify evidence and look for evidence. We're not here to determine the law and the legal standing of things. We're not here to determine who owns what. We're here to determine where are the things that are owned. That's really what it comes down to.
So, hope you enjoyed the chapter. This week, we're going to have a quiz, 7, Chapter 9 slides. The quiz opens on Tuesday. That's going to be April the 8th. And then it will close on the subsequent following Monday, which is, I think, it's April the 14th. So, please make sure that you take the quiz. It's off the Chapter 9 slides and notes out of the book. Also, remember that the semester paper assignment is due April 22nd by 5 p.m. Don't wait to the last minute to get started. I've also put up some new announcements and some new information about how our course has changed a little bit from the tentative schedule that I gave you before. We're going to cover chapters 14 and 15 next week. We're going to get ready for those and kind of cover roles and ethics. It's really important that you get that chapter. We're then going to talk about the final exam, and guess what, folks? We're already here at the end of the semester. I hope you've enjoyed the semester so far. We got a couple chapters left to go through, and I hope that this has been enlightening to you, and I hope you also keep the book and use it for future reference. Hope you have a great week. Hope everything goes well for you, and we'll see you back here next week.